Okay, so we're going to review civil rights and civil liberties here in the winter of 2014 in AP Government. Approximately 10% of the AP exam will deal with civil rights and civil liberties. So it's not a huge portion of the test, although it's usually a high interest portion of the test. The development of civil liberties and civil rights by judicial interpretation. So really, they don't ask a ton of questions about court cases. They ask a few. But it's just as easy to learn what these constitutional principles are that have been decided through court cases while naming the court case. So here we go. These are some important cases. Marbury versus Madison established the principle, well, it didn't establish, but it reinforced the principle of judicial review. There was an assumption by many that the Supreme Court would have the power of judicial review, and the Supreme Court said as much with this case, Marbury versus Madison. And this is the one about the judicial appointments and a change in president, and Madison, as a secretary in the cabinet, fails to deliver the papers that the former president had signed, and it goes to court. Marbury challenges because he was going to get an appointment, and it goes to the Supreme Court. The Supreme Court basically said that this is not something that they really should get in the middle of, but they established that they had the right to review conflicts, constitutional conflicts between branches, etc. And they also said that Jefferson and Madison were in the wrong side of this, even though they couldn't really rule against them. Mcculloch versus Maryland. Implied powers. This has to do with the National Bank and the state of Maryland trying to tax the National Bank, and the operator of the National Bank refusing to allow Maryland to tax them. It goes to court, and one of the arguments against the constitutionality of a national bank is that it was not mentioned in the Constitution, and therefore you couldn't establish a national bank. The courts pointed out with implied powers, the necessary and proper clause, that also known as the elastic clause, that because you have the necessary and proper clause and because you have this thing called the commerce clause, a national bank is implied, that the power to establish a national bank is implied through the necessary and proper clause and through the power of Congress to set laws to regulate commerce, that this was merely a function of its regulation of commerce. So therefore, implied powers was established firmly in the minds of our political leaders. Gibbons versus Ogden had to do with regulating interstate commerce. If you guys remember this case, it has to do with licenses for steamboats, with the state giving one party a monopoly and the federal government giving a license to another. So you have a state law, a state monopoly, involving interstate commerce in conflict with a federal law. Federal law wins for two reasons. One, interstate commerce is the purview of the federal government. Two, if a state law and a federal law were to be in conflict in an area that both could govern, according to the supremacy clause, federal government's going to win.
Oh, like marijuana.
Yeah. States can legalize marijuana all they want if the federal government doesn't want it legalized. Because it's interstate commerce, they can regulate it, even though they're choosing to kind of not do much about it right now. Yeah, that was a good comment there. Dred Scott versus Sanford. This has to do with slaves and descendants of slaves. It is a very controversial decision. It also involves taking a slave into a so-called free state, and the slave Dred Scott arguing that, hey, that means I'm free because I was taken in a free state and slavery is not legal there, etc., etc. A Southern sympathizing Supreme Court decided that nope, he's not free. In fact, you can't even be a citizen if you are a slave or a descendant of a slave in the United States. It basically set things up for a really big clash between the North and South. It wasn't the only thing. There were plenty of reasons why the North and South were going to clash. Primarily because there was slavery in the South and it made money. And the North there wasn't slavery, and because the North was industrializing, the South wasn't. The North's population was growing faster, and power in the legislature was increasingly moving to the North, and that was leading to economic conflicts between the two portions of the country. Plessy versus Ferguson. This is another one of those court cases we're not very happy with or excited with. This is the case that basically argued that segregation was constitutional as long as it was equal, as long as both groups had the same things. So in this case, if both groups could travel on a train, separate but equal, it's all right. That's the argument that they were making. Interestingly, there was a dissenting opinion. It was a very good opinion. He nailed it, and feel free to go read the dissenting opinion. If you don't know what a dissenting opinion is, it's when someone on the Supreme Court writes up his opinion which disagrees with the majority and explains why. All right, Ex parte Milligan. You can't use a military court when a civilian court is operating. All right, so this is a Lincoln issue. I know a lot of people think Abraham Lincoln, stood there and opened up his coat and there was a magical S on his chest and he could fly through the air and, Superman and all this kind of stuff. But he did some things that we would consider to be kind of controversial. People who criticized the war effort in the North, who were not in an area where conflict and combat was actually happening, were sometimes imprisoned and not given their due process rights, not given habeas corpus, things like that. Ex parte Milligan basically said, look, if a guy up in, New York, where there was no battle fought, thinks that the North shouldn't be fighting the Civil War, you can't just, put them in jail because you don't like what they have to say. He's not in the war zone, so to speak. There's no jeopardy in allowing him to speak, just because he's politically a dissenter. All right, so that's Ex parte Milligan. Brown versus Board, separate but equal, is unconstitutional. So I don't think I need to go into that very much. I think that's one court case, along with Plessy versus Ferguson, maybe Dred Scott, that we've got a real good handle on. Mapp versus Ohio established the exclusionary rule. It's one of those search and seizure cases. It's the one that pointed out that Dorley Mapp in her house had some dirty magazines. The warrant, the police officers were searching her house for an escaped fugitive or a wanted man, I can't remember which. And bottom line is they were searching for a guy. And somebody opened up a little drawer and found her dirty magazines, which at the time, nowadays would probably not be considered a crime. Not that I know what was in there, but all I know is they were pornographic. But I suspect the chances are that now that wouldn't even be a crime. But at the time, it was definitely a crime. And anyway, the defense, Mapp's defense was essentially they had a search warrant to look for a guy. Why are they looking in a drawer? He can't fit in there. And the court agreed that they had stepped out of bounds of what the search warrant was for, and they didn't allow them to use the magazines as evidence to charge Mapp because it was an unreasonable search. So therefore, they excluded the evidence and no trial, in effect. Gideon versus Wainwright. You have a right to counsel during trial. And this has to do with a Betts versus Brady decision that happened before. Anyway, the point is that if you can go to jail for a reasonably long time, you get a right to counsel. This was kind of up in the air for a long time, and they eventually established this right. And this applies to state laws, not just federal laws. So Gideon was a guy who was basically wrongfully convicted of robbing a pool hall that he had a key to, but someone broke through the window. And anyway, bottom line is he had a record when he was young, and because he had a record when he was young, when they convicted him without him having counsel, he went away for a long time. So he wrote, up his letter, sent it off to the Supreme Court, and they agreed that he should have had counsel at his trial constitutionally. Escobedo versus Illinois, you have a right to counsel while interrogated. If the police are going to ask you questions and you request counsel, or you request that you be allowed to bring your attorney, they cannot deny you that right. Anybody watch Law and Order probably knows that. All right. Although it's amazing how dumb those lawyers are in some of those interrogations, because instead of saying, okay, this is over, they just go ahead and let their clients hang themselves in the interrogation. It's very weird. Just very unrealistic.
If you're arrested and you call your lawyer, you can leave? Like, you can leave any time?
Not if you're arrested.
But if you're not charged with anything?
If you are not charged with anything, you can leave.
Okay.
Chances, are if they're like acting real, they're all standing around you, they might arrest you right before you leave. But yeah, and and remember,
stupid, so they can hold you in there.
And remember, the police don't have to tell you the truth. One of the things they do to get people talking is they kind of fudge. They kind of lie a little bit to get you worked up, and then you start saying things. All right, Miranda versus Arizona. Everybody knows the Miranda rights case. You have the right to remain silent. Anything you say can and will be held against you in a court of law. Blah blah. That kind of stuff. That was established here. He's not a very bright fellow. He basically was. Argued he was coerced by police. He was accused of rape. Anyway, they didn't get to prosecute him on that case with all the evidence they had, and it's pretty clear he probably pretty much committed the crime. But hey, there is a bright side to this case. Later on, he went around bragging to people that he was Miranda from Miranda versus Arizona. He ended up getting killed in a bar fight. Roe versus Wade. A person has a right to abortion through their right to privacy. And there are some complicated steps and limitations to the right to have abortions. In Roe v. Wade, depending on whether it's first trimester, second trimester, third trimester, but it used the privacy right concept to argue that a person has a right to abortion. Regency University of California versus Bakke argued that reverse discrimination is unconstitutional. You can't. This is the medical school guy. He wanted to go to medical school. He was a white guy. He scored really well on his test. He wasn't let in, and because University of California had a quota. They had a certain number of slots that they were going to hold for various minorities, and even though he outscored the people that they had that set aside for, he wasn't allowed in the medical school. He sued, and the courts agreed that you couldn't have a hard and fast number of any group that you were going to automatically put in, no matter how well anybody else did. U.S. versus Nixon. Nixon wanted to use executive privilege to hold back stuff from some congressional investigations. You guys probably remember Watergate and all that. And Supreme Court said, no, executive privilege has its limits. If legislators are investigating wrongdoing by the executive branch, there's a certain limit to what can be withheld. Gitlow versus New York. This is an extension of the Bill of Rights to the states. This is the beginning of the incorporation cases where your Bill of Rights protections that used to only apply to the federal government are going to start applying to state governments. So if you guys remember, it was decided long before with the Barron versus Baltimore case in the 1800s, early 1800s, that the Bill of Rights only applied to federal law. That if you didn't have a Bill of Rights in your state, that it didn't really matter. Okay, so Gitlow gets this started, and then there are a bunch of other cases that start incorporating the Bill of Rights. So most of the Bill of Rights now is incorporated, which means that states cannot interfere with those rights. Okay, so that last slide was a lot of cases that have definitely appeared on AP exams. All right, and some of these have as well. Some of these may not have. Texas versus Johnson is the flag burning case. There's actually another flag burning case as well, but this is Texas versus Johnson. Established that Texas could not have a law preventing the burning of a flag as political speech. Quite simple. RAV versus St. Paul, on hate speech. Basically hate speech can be somewhat controlled, but there are limits. You might want to look into that some more. I'm not ready to go into detail on that. Near versus Minnesota, prior restraint. All right, so this deals with the issue of whether or not the government can stop a newspaper, for example, from publishing something, and it established that prior restraint is next to impossible for the government to do. And please feel free to go review prior restraint if you're confused about that. New York Times versus the United States is another censorship case. And in this one, it has to do with the ability of the government to stop newspapers from publishing papers that were leaked, that were considered government secrets. And the courts basically said that documents that were leaked that were not going to do material harm to the nation. And by that term, like nuclear launch codes or something like that, if it's just going to be politically embarrassing, then the government just has to deal with it, and that the papers can publish that. Hazelwood versus Kohlmeyer established that the school principal acts as editor of student newspapers and has the power to censor student newspapers and edit them. Because the schools have liability with school newspapers. So this rattled around in 1988. I was in high school at the time. In fact, I was in the newspaper class, and our newspaper quality diminished massively because our principal was a bit concerned about controversy. And we're not talking about like local controversy. We're talking about controversy in general, which is pretty much everything that you would write in an editorial page. So therefore, we were reduced to talking about why there should be a microwave in the lunchroom rather than, issues of the day. The year before, we had editorials about, foreign affairs and, like a guy who used to be in the Nazi Party who was going to be the chief executive in Austria, and how we didn't care for that and stuff like that. And we're reduced to just domestic stupidity. It's kind of sad. Anyway, just a little personal aside. Hazelwood versus Kohlmeyer, student newspapers. Students have very little control over the limits of the content in the student newspaper. Reynolds versus the United States. Guess what? You can't marry more than one person. You don't have a constitutional right to be polygamist. At least so far you don't. We'll see what happens. Pierce versus Society of Sisters deals with religious schools and the limits to which you can provide aid to religious schools. Lemon versus Kurtzman has to do with the Establishment Clause. Actually, Pierce versus Society of Sisters, you want to do some research on that. I should have looked over that before I went in to this, but hey, whatever. Lemon versus Kurtzman, Establishment Clause. That's the one that establishes the Lemon Test. The one that says that if there's going to be any aid to a parochial religious school, that it has to be neutral to religion, that it has to serve a secular purpose, and that it has to avoid an undue entanglement, complication, too strong a connection between government and religion. West Virginia State Board of Education versus Barnett has to do with the pledge, basically with the Pledge of Allegiance, you can't make anybody do the Pledge of Allegiance. But last I heard, you could make people be respectful while other people did the Pledge of Allegiance. So there you go. Wisconsin versus Yoder. This has to do with school attendance. This was an interesting case. The court decided to allow Amish families to opt their children out of school after 8th grade. Kind of interesting. I'm not sure that they would have made that decision in Wisconsin versus Yoder in today's environment, but at the time, the idea that everybody should get through high school was not quite set in stone as it is now. Wallace versus Jaffrey has to do with the issue of religious indoctrination. I invite you to go read up on that. Buckley versus Vallejo. This is a case that argues that personal campaign contributions equal free speech. So therefore, if you are running for an office, you can spend as much of your own money, not money other people give you, but as much of your own money as you want on your campaign. Okay, so knowledge of substantive rights and liberties. The issue of clear and present danger. You need to understand that in order to prevent someone from exercising free expression, etc., the standard is clear and present danger, although the guy who came up with it is not exactly excited with it. Oliver Wendell Holmes. Shouting fire in a crowded theater could cause a riot, could cause a panic, and people get hurt. So therefore, that is not protected speech. So protected political speech only goes so far as it doesn't present a clear and present danger. So doing anything that incites a riot is not protected speech, if it's reasonable to assume that is its intended purpose. For example, when Rodney King was found, when the people who beat up Rodney King, the police officers, were found not guilty, simply stating that they were not guilty and then a riot happening does not mean that your speech could have been censored there. Symbolic speech is protected speech. If you make a political statement by raising your fist, that is protected. If you want to burn a flag, that is protected. Symbolic speech. Prior restraint. We've talked about prior restraint. That's the kind of censorship where you don't let somebody publish something or show something. That's extremely hard to justify in our system. Speech plus preferred freedoms. This is another concept. Certain liberties and rights are considered to be more important than others, and when they conflict, these certain rights, for example, your free speech, tend to win. There are only a few, there are special circumstances where they don't. The Due Process Clause of the 14th Amendment. Super important for you guys to understand that the Due Process Clause in the 14th Amendment is one of the huge reasons why we started incorporating the Bill of Rights. How the Supreme Court made the decision that the Bill of Rights also applied to state laws or with different cases is through the Due Process Clause of the 14th Amendment. The Due Process Clause of the 14th Amendment also helps deal with issues of equal protection under the law, frankly, in a lot of ways. So this also applies to race issues. Rights to privacy. Griswold versus Connecticut and Roe versus Wade are the two big cases that have to do with rights to privacy. Both have to do with reproductive rights as well. And the right to privacy is based off of, it's not literally in the Bill of Rights, but what the Supreme Court argued is that you could see through various other protections that there was an assumed right to some sort of privacy. And so that's why they ruled, for example, in Griswold versus Connecticut, that The state could not prevent married couples from using prophylactics as a form of birth control. Civil liberties versus civil rights. Recognize the difference between the two. Civil liberties are individual freedoms and rights that you might have. Civil rights has to do with the application and protection of civil liberties for groups of people. So when you're talking about what your rights are, you're talking about civil liberties. When you're talking about the government protecting the rights of African Americans or women or young or the old or so on, that's civil rights. The impact of the 14th Amendment on the constitutional developments of rights and liberties. Most of the Bill of Rights has been incorporated. What has not been incorporated? If you'll notice right here, there's an update. At one time, I would have taught my students that the right to bear arms was not incorporated. But as of D.C. versus Heller and McDonald versus Chicago, the right to bear arms has been incorporated as of 2008. So if you hear anybody tell you that people do not have an individual right to bear arms, that's old news. That was what some legal scholars thought for a long time, but the Supreme Court in 2008 said they were wrong and said that in their interpretation of the Constitution and writings of the time when the Constitution was drafted and the Bill of Rights, etc., that there is an individual right. But things that are still not incorporated, the quartering of troops. So in theory, in time of distress, well, really not necessarily in time of distress, in theory, the state government could make you have troops live at your house. But the federal government can't do it. State government could. Not incorporated grand juries. States aren't required to use grand juries. Trial by jury in civil cases. That hasn't been incorporated either. So here's a list of court cases that have incorporated various Bill of Rights protections. Remember, incorporate means that it goes from being something that a Bill of Right liberty that only applies to federal law. Once it's incorporated, it applies to state laws as well. So 1925, the Gitlow case, free speech is incorporated. In the Neer versus Minnesota case, 1931, the free press, freedom of the press. DeJong versus Oregon, freedom of assembly and of petition, that was in 1937. Free exercise clause that has to do with religion and your right to practice your religion. 1940, Cantwell versus Connecticut is the case. Establishment clause has to do with separation of church and state. That's Everson versus Board of Education in 1947. So you see this period of time where there seems like there's a steady incorporation. Seems like every 6 years or so there is an incorporation case, and then there is a break from 47 to 61, and then 61 you get the Mapp versus Ohio case, which incorporates search and seizure protections in 1961. You get the Robinson versus California case in 1962 that has to do with cruel and unusual punishment. You have Gideon versus Wainwright, the right to counsel in 1963. Malloy versus Hogan, 1964, the right against self-incrimination. Pointer versus Texas, 1965, the right to confront witnesses. It amazes me how if you pay attention, you'll see certain names pop up. And Texas shows up a lot for things that just kind of, if you think about what Texas was trying to do, should make you cringe. Let's see. Washington versus Texas, 1967, the right to a speedy trial. Duncan versus Louisiana, trial by jury in criminal cases, 1968. Benton versus Maryland, 1969, double jeopardy, so states can't try you twice for the same crime. All right, D.C. versus Heller, right to bear arms, 2008. All right.
So if you